Director of X Cathedral Solutions Limited, and we provide a wide variety of data protection services and cybersecurity services, which we'll talk about in this presentation. This presentation is going to be about data protection, legal responsibilities and subject requests. I'm now going to share a slide deck so you can all thoroughly enjoy that, and I'll disappear down into the bottom corner there. Okay, so first off, let's be clear on what our audience is here, okay? This is intended for people who are managing data in organisations or handle data subject requests on behalf of those organisations. You can freely use this within your organisation for training, but obviously I don't make any warranties about it, about correctness or completeness. If you're a customer of mine, hello customers, lots of you, okay, feel free to contact us for further information and definitive DPO advice, which is in your contract. So what we're going to cover? Well, we're going to cover the general data protection rights that come from the principles. We're going to talk about what we need to do for those rights, and then all the requested rights. There's quite a lot of them in the UK GDPR. We're then going to talk about how we manage what we need to do to make sure we handle that correctly, and how we deal particularly with Article 15, because that's the big one that always causes people challenges, the subject access right. We're going to talk about all the other rights as well, okay, some in more or less detail, but should be enough to assist you in your processing. I'm also going to talk a bit about FOI, and the reason for that is because people often confuse FOI, EIR, and the data protection law. So basically, this is because you may get requests which say, under FOI, I request all of my data, that sort of thing, how to deal with that. Obviously, there can't be Q&A because this is recorded, but there is a contact address at the end, and of course, customers have got their own contact details if they need it. Okay, so you're all probably familiar with the 6 principles of the UK GDPR. I've shortened them here because they are quite wordy. I think the people that were originally drafting this legislation were paid by the word or something, because it's a bit ridiculous. But anyway, these are a summary of them. I'm not going to go through them in this session. I've got other sessions about that. But just so you're aware, okay, let's look at the effects they have on granting people a right. So the first thing is, okay, that the first 2, which are lawful, fair and transparent processing, and specified explicit and legitimate purposes and not further processed in incompatible manners, that requires that we have privacy notices and tell people what we're doing. Okay, it's got to be done before the data is collected. So you must have this detail at minimum on forms, or provide your privacy notice at the time you're collecting it. And we can't then change our minds about what we're going to do. So we can't collect data for enrolment in a school, for example, and then use it to advertise, I don't know, childhood vitamins and like that. It's not allowed. Okay, so we've got to be able to do that. There are ways we can get to change things, but they do involve in the data subject. The 3rd, 4th and 5th principles, okay, basically restrict what we can do with data when we've got it. So we've got to keep it adequate. It's got to be adequate. We'll have the data we need, but no more than that. It's got to be limited to what's necessary. It's got to be accurate and, where necessary, kept up to date. So if we're keeping it, okay, we need to update it and make sure it is up to date. So for example, if you go to your GP surgery, they should do something like at reception, oh, by the way, does your mobile phone number still end in 559? And can you confirm that your house address is still 119? That sort of thing. Okay, you need to be very careful doing that, okay, to make sure you're not disclosing data to anyone else in the surgery, that sort of thing, but that should happen all the time. Give people the opportunity to verify their data. As soon as we don't need the data, we need to get rid of the identifiers from it. So we can keep summaries of the data, we can keep statistics, and in fact what's called the RAS purposes, research, archiving and statistics, are regarded as generally compatible in UK law, slightly different in EU law. Okay, so bear that in mind. So we need to remove that. Bear in mind that archives are a big thing. One of the big challenges with data protection law is that people like National Archive really struggle now to get data relevant that they keep for historic purposes. Archiving is almost always allowed, so be aware of the fact you can pass things to National Archive if they're of archive relevance. So what about the 6th principle? Well, that says that things must be processed in a manner that ensures appropriate security. So security of your data is effectively a right. And you can and will get civil claims as well as regulator action for security breaches. Believe me, I deal with a lot of them. Okay. Now, being trained appropriately is a big part of appropriate security. So you need to look at your organization's training and make sure you've got appropriate training for all the staff that are involved. And you can use this, if you so wish, as part of that. Now, everyone talks about 6 principles, but there's a secret 7th principle. Okay, this is called the accountability principle. It's the second part of Article 5. And what it says is that the controller shall be responsible for and be able to demonstrate compliance with the principles. Okay, so we've got to be able to produce all our documentation for all this stuff on demand from the regulator. We've got to be able to evidence that we're doing all the right things around making sure we can deal with the rights. And that's what we're going to talk about the rest of this presentation. When they ask, they generally in the UK give us 7 days, no more. Okay, so you have to have this stuff ready. You can't retrofit it. Okay, and they can also, if they wish, do a mandatory inspection. That's quite rare, but it has happened. So bear in mind that they have these rights, and you have to make sure you've got all your documentation, all your privacy notices, you've informed your data subjects correctly, and you've done all the bits you should have done before the regulator knocks on your door. So that's the end of the sort of general rights again for the principles, okay? And we basically bear in mind the fact that in the UK, the ICO, in other countries, the regulators can inspect us at any time and can ask for our accountability documentation with a very short notice. So I'm going to move on to talking about the subject rights. There are 99 articles in the GDPR and 10 of them are about subject rights. So it's obviously quite important. So bear in mind, okay, that a large part of the legislation is devoted to the rights of the data subject. Now I'm going to go through each of these in turn. Okay, some of them are fairly straightforward. Some of them will take a little while, especially Article 15, which is probably the most challenging one for most organizations. So Article 12 is what they call modalities. Okay, now modalities is a bit of an odd term. Okay, but what it really means is how you have to do things with the rest of the rights. Okay, but they also talk about transparent information here. So you've got to provide the information at the time of data collection when you get the data off them, or when someone exercises their rights. So technically, you should be providing all your information about your data users when you provide a data subject access request. Most people don't, but you should be. Okay, and we need to say on forms and web forms and stuff like that what we're doing with the data, what we're going to be doing with it, and we cannot charge for providing information or exercising rights with some exceptions. We also must provide things in an accessible form, and yes, that does mean things like having to provide in Braille if the customer is data subject is blind and reads Braille and cannot read other text easily. Okay, we've got to facilitate the exercise of rights. So what that means is you can't stand in the way of the rights. You can't make people fill out complicated forms or jump through hoops or speak to someone who's only in on Thursdays on the third Friday on the third week of the month. Okay, you must make the rights available to them at all times. So we can't put anything in their way. The only thing we can do is identify the data subject, but we must ask them to identify clearly and explain why we're not clear about their identity. There's a thing in the legislation about having standard icons and stuff like that. That hasn't really taken off, but be aware of the fact it is there. It may do in the future. At the moment, it's not really clear. And bear in mind, unlike other legislation, requests do not have to be in writing. They can simply ask any representative of the organisation. That means they can literally walk in and say to your receptionist, I want to receive all my data, okay, and you have to deal with that as a data subject rights request. Bear that in mind. You've got to be able to exercise rights without undue delay. Now, that's a maximum of 1 calendar month. It's not 30 days, it's not 28 days, it's not working days, it's 1 calendar month. Bear that in mind, unless there is complexity or a large number of requests from the same person. Now, you can also be some exemptions for things like campaigns and stuff like that, okay, but you need to be very clear on why you're doing that. Okay, you can extend in that first month for a further 2 months if it's complex, but you have to tell them in the first month. You can't get to the end of the month and go, oh, we've managed this, and then try to extend. That is not legal, and you will get an ICO notice on that if you do it. Okay, so bear those two in mind. Okay, you have to start dealing with this stuff fairly quickly. Some requests can take a long time. Common example that I came across is where you're dealing with medical practitioners or schools, and social care is involved in there, and there are possible risks to individuals, okay, or police involved as well. Those sort of things tend to take time to consult and stuff like that, and that can push it past the 1 month limit. So make sure you're clear on that. Articles 13 and 14 talk about information to be provided to the data subject. Now, 13 is when you've got the data for the data subject, 14 is when you've got it from other people. There's quite a lot of overlap between them. So all of the things listed there have to be provided for both of them. Okay, now some of those things people leave out of their notices, in particular online privacy notices, where they don't include things like the contact details of the DPO, the fact you've got the right to lodge a complaint with the regulator. Okay, so those, you need to use that as a checklist to make sure you've got all of those things in your privacy notice. If you don't, it's not compliant, simple as that. And unfortunately, I see a lot of non-compliant privacy notices. Article 14, as I said, is when it's come from someone else. You also have to tell them where you got it from. What if the process is based on legitimate interest, which I'm not going to cover in detail, but if someone wants a talk on legitimate interest, I'm quite happy to do it. It's an interesting topic. Okay, what those interests are and where we got the data from, even if it was from a public source. Even doing things like scraping things off websites, okay, requires to be notified. You may occasionally get emails from people saying Article 14 processing notice. Okay, that's because you have a right to object and refuse. I just tend to automatically say no to them unless it's very clear to me that's going to be a benefit to me, but that's my choice, and I'm a geek. Okay, but you have to provide all information for both articles if they're applicable, but before processing. Bear in mind that public bodies cannot lose legitimate interest. Okay. Okay, that's a weird sentence. Sorry, that sounds a bit odd. Okay, anyway, we can't use legitimate interest. There are some weird things about this where you have to use legitimate interest because of the way the law is written, but you can't use it for general processing for your purposes. So, for example, if you're a local authority, you couldn't use legitimate interest for doing things that are within the statutes around being a local authority. Okay, such as housing, social care, etc., etc. You can only use the public task, and there are some others as well, but basically that's the most common one. One thing that happens in the market about cookie law particularly is people think that legitimate interest allows them to process data for cookies and stuff like that. It doesn't, never has done. UK law is very clear it's got to be consent, but people still do it. There's a lot of deceptive practice, and there are certain newspaper groups, for example, that used to have really, really complicated things. Even if you said no to everything on there, you would still end up getting data processed for the hidden legitimate interest. They've now moved to paywalls, so we don't care. Okay, but bear that in mind. Okay, it's quite important to be aware of what's happening to your data. Otherwise, you get unexpected things happening that you may find concerning. So watch out for that legitimate interest thing. Okay, so let's look at the subject access right. This is the big one. Okay, get your popcorn out. Okay, make sure you keep hydrated. This is going to take some time. Okay, so basically, the subject access right allows any person to have a copy of the data that is being processed by you. Now, who can apply for it? Well, the data subject can, duh, okay. Also, a person with parental responsibility if the data subject is under 18. But you need to check if the child is competent. Children are commonly competent around 11 to 12, so we'll have to talk about that separately later. A person with a lasting power of attorney or deputyship, but please check the powers of deputy. A solicitor who has been instructed by the data subject, and anyone to whom the data subject has clearly consented to act on their behalf. I'll talk about that group later. Now, bear in mind, I'm talking mostly about UK law here. Law in other countries is not dissimilar, okay, but those terms are fairly specific UK. One thing to note here, okay, is if the child doesn't have competence because of mental impairment or something like that, when they turn 18, you suddenly have a problem where it may not be possible for anyone to actually ask for their data. Now, we can be acting in the best interest of the child, so things can happen here, but it's a very, very good idea if you have got a child with mental capacity issues or other issues that mean they're not competent, okay, to get a deputyship for them before they turn 18. Okay, it's very, very important in a lot of other areas too. I speak from experience as a parent of a child with such disabilities. So what have we got to supply with the subject access required? Well, we've got to supply all of the Article 13 requirements, and 14 actually. Okay, so we've got to supply all of that stuff, okay? We've got to supply the data they requested, and they can say all data, and frequently will, okay? And we've got to do a reasonable search for it. Now, be very careful of that term. Okay, reasonable search does not mean that if you've deliberately thrown everything in your own filing cabinet, you don't have to produce it. That would be regarded as not following the accountability principle. You have to organise your data properly. You should be able to produce the majority of the data for a person easily. Again, if you can't do that, you're not handling your data properly, and you probably won't be, as I say, following the accountability principle. We have to provide it in a form they requested. So they can request it electronically, they can request it on paper, but it's one copy. They can't ask for both. So if they do ask for both, you say to them, well, which do you want? Okay, because obviously, I've got to charge for one of them. And if you want it electronically, I'm going to charge, for the paperwork. Okay, that's legal. You can say that. Bear in mind that if someone has asked electronically and has not stated what they want, we can assume electronic. Okay, I'll talk a bit more detail about what we need to provide in terms of the data, and we can't charge unless the request is repeated or excessive. Now, repeated means they've asked for the same data again. It doesn't mean that if they ask for different data. So, for example, someone put in a subject access request every 18 months, okay, asking for the data for the last 18 months. It's perfectly legal and legitimate. They're allowed to do that. Okay, you have to deal with that. The timescale, as per Article 12, is 1 calendar month. Bear in mind that bank holidays, school holidays, high days, holy days are all included, and that you can extend to 3 calendar months in some circumstances, but it should be rare. So we have to provide them with everything. Well, we don't want to provide them everything. What can we remove? Okay, so we can take out things that would adversely affect the rights and freedoms of others. So commonly, this is things like third-party statements where I said patient here because this was originally a slide for GPs. Okay, but basically where something is entered in the record that the other person didn't expect to be given to that data subject, that would commonly be exempt. Generally, staff data in a professional capacity is not exempt. We have to provide their names. We don't necessarily have to provide their contact details, and FOI has got slightly different rules on that, but under DPA we don't have to supply contact details. So you're perfectly at liberty to redact people's personal emails and their mobile phone numbers. You can't redact their names as professionals, and you also can't redact things like which organisation they work for and things like their GMC number, stuff like that. All of that would have to be provided. Okay. Sometimes we can remove things where they create a risk of harm. Okay, so a common one we see in GP land is that we get a subject access request from parent A with their child. The parent is separated and there's known domestic violence, and parent B is in a safe house or something like that. Parent A requests the medical records. Parent A is allowed to have the medical records. Okay, we cannot gainsay that. That is their right as a parent, assuming the child is sufficiently young. So we can redact the address that the parent B and the child are at, okay, and we can also redact the fact they're coming in to see us next Wednesday, but we can't redact the medical records, and we can't refuse to provide the medical records. Bear in mind that parental rights are indivisible. Both parents, whether they live with the child or not, whether one parent's in jail or not, okay, doesn't matter. The only place that the parental rights can be removed is by the family court in the UK. If it hasn't been removed, they've both got the same right. So let's talk about some more exemptions. What else can we remove? Okay, so there's a huge number of exemptions in DPA. Okay, there's stuff around crime and taxation, immigration, public protection, legal requirements, all of those where it would prejudice the purpose of the thing. Anything that causes serious harm, as I previously mentioned. Anything that's against the data subject's expectations and wishes. Now, that can be quite complicated. That normally comes up when either someone's provided third-party information. A mother of a child came in and said that, I'm seriously worried about their mental health and their substance abuse. Okay, that would be recorded and a conversation may be had, but we wouldn't disclose that had been said. Okay. We can remove safeguarded child abuse data where it would cause a risk, that sort of thing. Okay. We can also remove data for self-incrimination. So yes, we can remove data that says we've broken the law, but I don't recommend it. Okay. Legal professional privilege stuff is exempt. Okay. Confidential references, negotiations, exam script marks, journalistic expression, and it's a long list. Okay. Please consult your DPO if you're looking for an exemption. For my customers, of course, you can come straight to me, and there's a recording form. Okay. So we now know roughly what we need to give people and what's exempt. How do we get it done? Okay, so I summarise this as 6 R's. Okay, I like my acronyms. Okay, I mean mnemonics. Okay, so first of all, we receive the request, check the right of access, check what they're asking for, acknowledge, but make sure you've got clear identity. The clock doesn't start until you've clarified identity, but you can't delay. So basically, you can't receive a request, leave it for and think, oh, by the way, you need to verify identity. You have to do it in day one, as soon as you receive it. Okay. If it's a really complicated or big request, tell them now if you won't be able to complete the month and exercise the extension. Don't wait. Okay. Now, bear in mind, you must always deliver as soon as practicable, and in any case by the correct date. So even if you extend, you may still deliver the first month, but you may have extended because there was a risk you wouldn't. Okay, so just bear that in mind. Record the request for tracking because that's important to evidence that things are duplicated and stuff like that. And I've got a useful spreadsheet for that, of course. I've got a spreadsheet routing. Okay, round up all the data that's required, get it into one place and preferably into one format. Adobe PDF is probably the most commonly used because the readers are free. It can't be in a format that requires the data subject to pay for a tool or to even install a separate tool. That is not a common one. There's been quite a lot of argument about this, but basically Adobe PDF, HTML, are considered acceptable. Microsoft Word documents, not so much. Okay, Excel spreadsheets, that sort of thing, not so much, because people have to pay for software to access those, so bear that in mind. Review it, okay, so go through and decide what needs redacting. Record what you're planning to redact, why and what exemption you're using. Then do the redaction. I'll talk about how to do that in a minute because people do get this wrong. Okay, and then respond to the requester. Now, you need to keep a record of that, okay? You need to record that you've closed it, okay? But also keep a record of the site and keep the data. Now, the recommendation is 3 years here. The reason for that is because that is the likely time for them to appeal to the ICO. If it is appealed, recommend you keep it at 6 because that's the normal time of the Limitation Act after which claims can't be brought. Okay, so just bear in mind you need to keep the data you've given them, the redactions, why you did the redactions, all that sort of stuff. It's quite important. Okay, so redaction is a thing we have to do, okay, to protect the rights of others, but it's we can only do it where it's legally required. We can't redact stuff that's just embarrassing or where it's shown we cocked up and stuff like that. We can redact for some harms. So, for example, safeguarding information in a child's school record, which, if revealed, may cause distress, okay, or cause serious harm, we can redact. We can redact we've broken the law, as I mentioned previously. I don't recommend that because it's going to come out in disclosure anyway, so really don't bother. Okay, consult your solicitors. I am not a solicitor. Okay, record your exemptions. Okay, and always keep the unredacted version in case of a dispute. So how do you redact? Well, a lot of people use whiteouts, Tipp-Ex, the common brand name, okay, and then photocopy and then send the photocopy. That's perfectly fine. Don't just use it on a piece of paper you printed out because it can just be scraped off with a razor blade. Black market is not recommended, okay, partly because the Children's Commissioner has said that you shouldn't redact children's records in particular with black because it's obstructive to them. You should use a neutral colour. I tend to use 18% grey, which works fairly well, okay, and is less threatening than black. But it's also commonly less black than you think. If you're using a physical method, check it under bright light, check it at an angle, because it can be deceptive. Common things we see are things where people don't realise that the text underneath can still be seen if you hold it at right angles to a bit of light and stuff like that, because the text is slightly raised. Okay. Electronic redaction is preferred, okay, but be very careful with it because you often don't understand what's in the file formats. Adobe Acrobat does a reasonable job of redacting PDFs. Okay, and I said about using Great, you need to flatten the document and remove metadata before you send it. There has been, okay, quite a few cases in this. We've seen recently, for example, in the US, where they had not correctly redacted using Adobe, and people just cut and paste the text back in. Bear in mind that UK government made a mistake where they didn't remove the screen reader data from Adobe documents they released, which meant everyone could still read them anyway, because the text was still hidden in the metadata. That's why you need to use proper tools to do this. Okay, you don't know what metadata is in there. So just bear that in mind, okay. And I can assist obviously with my customers, but I don't expect me to do the whole of the SAR for you. I can help you with it. I can't do the whole SAR because you've got to do most of the donkey work on it. So common challenges include children. Okay, so first of all, with older children, we have to consult them. Okay, we've got to be very, very clear on that. Okay, they should be consulted on SARs made by the parent if they are competent. Bear in mind, it's always the child's data, no matter how old they are. The child can actually make a request at 5 years old if they want to. Okay, so the above applies to the other rights too, but in some cases you have to look at the age of competence. Scotland's defined this as being 13 years old, so they're easy. Okay, the rest of the UK, we haven't defined an age, so we have to do competence tests. And that may not be absolute, okay? It may apply to one decision, not another. It needs to be assessed. The child, you need to make sure the child clearly understands what's happening, the consequences if they say no and if they say yes. That requires somebody, a professional, to talk to the child. In GP land, we've got this thing called Gillick competence, which comes from the Gillick test, which is more about basically sexual health and contraception, but it does give us a clear test. Not the Fraser guidelines, by the way, for the GPs watching this. Okay, the Gillick test does give us a clear test for is this child competent, and we can do that. A very, very common situation is warring parents asking for subject access requests. As I said previously, each parent has the same rights unless withdrawn by a court, and it's only the family court that can do it. Each parent will probably object to the other parent having the data. They don't have a right to object, okay? So if the parent says, I don't want to have the data, you go, meh, it's not your right, okay? You need to follow the redaction rules very, very carefully, because commonly, if they are warring parents, the average mental age of parents that are getting divorced for some or separated for some strange reason seems to drop massively, and they act like kids in the playground quite frequently. I'm not dissing anyone on that. It's just that's just the way it appears to be to me after long experience with this. So please bear in mind, okay, that you need to make sure that any information there has been checked very carefully for harms. Okay, but if a parent says the other parent has lost parental rights, we need evidence. That will be a family court document. Okay, you can't just say it. Okay, just to be clear on what is a parent, by the way, a parent in UK law is somebody that was named on the birth certificate or has a certificate from the mother that has been certified by the family court or has an adversarial request to the family court that has been granted against the mother. Okay, gender of parents doesn't matter, number of parents doesn't matter. You can have multiple parents for a child, parents can be any gender. Okay, so bear that in mind. It is already complicated, so please, if you're a customer, consult me. And if you're not, I do consultancy rate as well, so there you are. Okay. Some other common challenges are, as I said, adult children. Okay, so where the adult child lacks competence, okay, technically we shouldn't be provided under Article 15 without a deputyship, or where the child lost competence before they became 18, a lasting power of attorney. That's got to be for health and welfare for medical records, can't just be for finance. So bear that in mind if you're dealing with medicine stuff. Okay, we can consider the child's best interests. Okay, now obviously you're skating on fairly thin ice here. Okay, so you have to be very clear what the child's best interests are and what you're releasing under. That's part of the reason you need a DPO to advise you. Okay, on this. If you get requests about deceased people, they're not SARs. Why? Because dead people aren't covered by the law. The law only applies to natural living persons. Natural, not a company. They're actually a physical person. Living, like it says. Okay? So if they're deceased, I'm sorry, the law doesn't apply to them. Also, LPAs and deputyships fall at death. Okay, so bear that in mind. So this goes back then to common law and some statutes. So, for example, in medical, you've got the Access to Medical Records Act 1990. There are other acts in other areas. Okay, but it's awfully complex. Okay, really, what you need to be looking at is the detail of what they're asking for, whether it's reasonable, whether there's claim attached to it. Like I say, it's complicated. One common thing we get is people saying, "Well, I've got a right to because I'm next of kin." Next of kin is not defined in data protection law anywhere, so it doesn't apply. Okay, this is a big problem, obviously, for values like competence I mentioned before. There's also things about school marks and results. There are other laws on that. Okay, so if someone's asking for school marks before they're released and these sort of things, there's law on that. Okay, so we need to look at that. There are loads of exemptions in the fields I mentioned. One that comes up a lot is references. Have I got that twice? I might have. Okay, you don't have to supply references. If someone's giving you a reference, okay, you do not have to explain it, and you can claim that's exempt, straight enough over the other law. The old law actually used to say the person sending the reference is exempt, not the person receiving it, which was very weird because it just meant the address of the other person. But there you go. They fixed that. Okay. One other thing we commonly get is what are called litigation requests. So if a person has appointed a litigation friend to help them with a court case, it doesn't have to be a solicitor, it's commonly an ordinary person, okay, they can have any information relevant to the case, but they can't have all data generally, unless for some reason all data is relevant to the case. But you need to have clarity they've been appointed from the data subject. Okay, advisors and advocates. We get this a lot, particularly at the moment with the pressure on immigration right to remain. We're getting this a lot with immigration advisors, people like that. Basically, the data subject hasn't got strong English or is unable for other reasons, say mental health, to actually challenge these things. So they ask someone to do it for them. Absolutely fine. Okay, they are allowed to have data that is required for that consent and required for their purpose. The other bugbear that we get a lot is personal injury claims companies and solicitors. What used to happen pre not paying for these, not being having to pay for these things, was that they used to pay GPs and other medical practitioners to give them a report on the patient's injuries, which would then go to the court. What they now do is they ask for the full medical record, and they then outsource, usually to cheaper countries in the UK, the production of the medical record. That's excessive data use by definition. They don't need the whole medical record for the purpose of producing a report. They need a report. But what happens is they get people to sign for this, and people do. There's a standard form available from the Law Society BMA. It's online. Literally search for Law Society BMA claim BMA subject access form. You'll find it, and that basically make sure the solicitor has explained to the patient, okay, that this is going to be excessive data, and it is their right to say no to it, and they can do other routes, but then they may not decide to support them. Okay, these people will also try to tell you the deadline is shorter than it is. I frequently get ones from saying you've got to produce this within 14 days and stuff like that. Okay, cobblers. A lot of them don't seem to understand the law particularly well, which is quite frightening when they're solicitors and personal injury claims. But there you go, that's what we got. So bear in mind, okay, read what the law says. Don't read what they say, because it's probably not correct, and they're probably just trying to rush things. Okay. As I say, if you're a customer, feel free to consult, because we get a lot of these, particularly in GP land. So to summarise Article 15, remember those 6 R's, how to actually do the whole thing, because that's quite important. Please consult your DPO if you've got one on redacted or complex cases. Make sure you record decisions. With children under 11, you can basically assume they're not competent. It's very rare for a child under 11 to be competent, but over 11, I'd suggest you decide if you believe the child is competent, okay, and that may need some sort of formal assessment. And bear in mind that requests for deceased people are not subject access requests under completely separate law. Okay, take a breath. That's Article 15. Okay. Article 16. Okay, right to rectification. So this is basically where the data subject says to you, that's wrong and I want you to fix it. Commonly happens after you've done an Article 15 subject access request. They've now seen all their records and they say these things are wrong. You cannot be asked to falsify records. That is fraud. In some cases, it can actually be also against professional principles, like GMC principles. So just bear in mind, okay, they can't ask you to falsify the records. Obviously, you should rectify general errors made, but even that is a bit tight. We need to be careful about that, but we can't change things that are factual, even if the patient disagrees, the patient or data subject disagrees. Make sure the change is recorded, especially if later decisions are made on it. Now, this is where you can get into quite a mess, and this happens particularly with things like medical records, school records, stuff like that. If you've made decisions on the basis of something that was incorrect in the record, you can't remove that thing from the record, because it then make it look like the later decisions were wrong. And therefore the data subject can then go, aha, that decision was wrong. You shouldn't have done that. You didn't have evidence of X, X being the evidence they asked you to delete. So be very, very careful about that. This is very, very common in GP land. We quite often get people saying, oh, yeah, I know I had mental health issues 10 years ago, but I want to join the army now, and I therefore want it removed from my record. Can't do it, sorry. Okay, much as I sympathise with you, and I respect the fact that you want to leave your country. We cannot give the army false information because we'd be legally liable. So we can't remove things like that. This is very common with people with mental health difficulties, I would point out, because sometimes they don't remember what happened and they think therefore it didn't happen. And that can be a real challenge, okay? And I've got a lot of these cases back and forth with the Information Commissioner over the years, where basically we know it happened because we got evidence. The patient says it didn't happen because they can't remember it. Okay, it's a challenge for everyone. Okay, be as sympathetic as you can, be as reasonable as you can, change things where you reasonably can. Okay, but when you can't, make sure you're very clear on the reasons for refusal. Article 17 is the right to erasure. No, it's got nothing to do with 80s bands who sang, my view, very poor ABBA covers. These are other stuff as well, which is better. Okay, it's often called right to be forgotten. Okay, now it only applies where one of that list of things is true. Okay, now bear in mind that in a lot of processing you have to keep things a lot longer than data subject might want because it can be legally challenged. So anything to do with finance, for example, you're allowed to keep for 6 years plus current year, Limitation Act, because they can sue you for things around finance. Medical records we have to keep for up to 50 years after death. Okay, because of course actions can be brought at that sort of limit. Some other things are even longer. So bear that in mind, okay, whether or not you must erase. The only one where commonly you have to erase really is where you were doing it by consent and they withdrew consent. In that case, you immediately have to erase the data, but that doesn't change the legality of what you previously did with it. Okay. If we've given it to anyone else or we published it, we have to remove it from those places well and tell anyone that we shared it with to remove. That's reasonable steps. It's one reason why record keeping is so important on these things. Okay, there are exemptions. There's loads of them again. Okay, freedom of expression is one. Legal obligation, obviously, if we've got to keep it for legal purposes, that's fine. Public interest, if it's an important public interest. Legal claims, archiving, public health. Okay, there's all sorts of others. At the same time as there's other rights, but you need to also consider the fact that if they object under Article 18 and ask for restriction of processing, you may have to stop using data immediately. Let's move on to Article 18. Well, this is restricted processing. They can request that we stop processing, okay, if the accuracy is disputed until we verify accuracy, if they believe the process is unlawful, but they don't want the data erased, if we no longer need the data, but they do, they need us to keep it because they got a legal claim, or if they object to our legitimate interest. Now, this can be really, really challenging in some areas, okay? So please, if you've got a DPO, use them. If you haven't, hello, available for hire. Okay, but bear this in mind. Okay, Article 19 is a bit weird. Basically, it just says under 16, 17, 18, you've got to tell everybody you've got the data, okay, unless that's an impossible or disproportionate effort. So, for example, if you publish something on a website, okay, telling everybody that the data is being removed too much for use is going to be impossible. Okay, disproportionate effort means really that it's really, really too difficult to do, and it's so difficult that it wouldn't be possible with reasonable means. Okay, and the data subject must be told about recipients. They should have been told in the privacy notices anyway. Okay, but commonly privacy notices are kept simple. It's a good idea to have tiered privacy notices. So you've got a level 1 privacy notice, which just gives the basics for compliance with law, and then a level 2 and then possibly even a level 3, okay, giving more detail for people that want to know more about data protection. If you want examples of this, have a look at any of the North Central London GPs that have used my privacy notices, because then we've got one privacy notice which is literally a page, and then we've got another privacy notice which is over 100 pages because it's covering every single detail of every single use as far as we can, and all the various rights requests and stuff like that. I don't particularly like it because it's horribly long, but at least that way people know exactly what's happening with their data. And it also does mean we don't get commonly things like, are you sharing data with Palantir and stuff like that, because we've already declared it. Okay. Right to data portability. Okay, this is an interesting one. It doesn't often apply, but they must be provided with their data in a structured, commonly used and machine-readable format. No one's ever really defined what that is, but I'd suggest that possibly XML is probably the easiest one because that's pretty reasonably portable. Maybe CSV at a push, but XML is probably better. But it only applies if the data was supplied by consent or for contract purposes. It's basically designed to allow people to move between social media providers, email providers, stuff like that. It doesn't apply to public tasks. If you're doing anything in the public sector, okay, including the NHS, it doesn't matter. Okay, you don't have this. But bear in mind, if you're using consent, then it can be. It's very rare to use consent in public tasks for various reasons. Okay. You will see this, for example, on Facebook. You can ask for portability requests from Facebook and you will receive your data in a machine-readable format. No one's ever actually got an import for it, but hey, the law didn't define that, so that's why. Okay. Right, Article 21, the right to object. You can object and say, stop, I don't want you to process that data anymore. If somebody does that, we have to demonstrate that we have one of the compelling legitimate interest grounds. Now, this is where it gets a bit weird because, of course, public sector can't use legitimate interest, but we have to here because it's the only way to do it. Obviously, our legitimate interest is the public task. Okay, but it's just a bit odd. Anyway, there you go. Okay, so you need to be clear on why your processing needs to happen. Okay, and it's got to be a strong enough test, and there's a standard test for this. Again, I've got a form for this if you really want it. Okay, to go through and fill in. Obviously, I help my customers create these. You have to emphasise the right to object on first contact with the data subject. It's got to be not just in your privacy notice, but actually on your form saying you've got a right to object. Okay. Right, Article 22. Article 22 was changed a lot last year by the Data Use and Access Act. So we used to have just Article 22, which basically said you had a right not to be subject to automated decision making or profiling. We now have Articles 22A through F, which have weakened is maybe the best word, the protections against automated decision making or profiling. Now, the reason this was done was in order to encourage the use of AI and the free flow of data. It was a political objective that was clearly in the manifestos. And it was actually in the manifesto of both parties. Both the main parties were talking about this. Thought we'd always something was going to happen. Okay, but basically, in the UK now, the data subject has safeguards required for significant decisions. Okay, there was a definition of significant decision. You can think about it pretty much as anything that would cause legal effects or possibly prevent them from doing something, that sort of thing. Okay, we can only use automated decision making if they've been informed of the processing, if they can obtain human intervention or preferably build it into the processing, which is far safer. Okay, and they can make representations to appeal and contest. The Secretary of State can define and change all of that lot, and they can also define and change what legitimate interests are and what significant decisions are. Okay, one of the things about the Data Use and Access Act, and I've got a video on that if you want to geek out on that. It's quite long and detailed, but one of the things about it is basically the Secretary of State can change a lot of it by a stroke of a pen. It's got one of the largest number of what are called Henry VIII powers that I've seen in any legislation. Okay. Bear in mind there can be subtle things here. So if you're automating sending to a parent of 6-year-olds, okay, that might be a significant decision if there's a legal effect on the 6-year-old. That sort of thing. It can be quite challenging to work these out. Basically, if you're automating things, look very carefully at this one to make sure it's not covered. Okay, so that's all the subject rights. That was a bit of a romp, wasn't it? I hope we all enjoyed that. Okay, so bear in mind that rights do not have to be requested in writing. You need to make sure your staff know that. You need to make sure that everyone that comes into contact with your customers knows that, whatever they are. Okay, and they're rights, not privileges. You can't refuse them. You can't put barriers in the way. They've all got a time scale of 1 calendar month, with the exception of the objection one. Okay, but you can sometimes extend to 3 calendar months. Remember that all of the rights have exceptions. We can use protect other people, and then you have the caution around automated processing. Okay, nearly at the end now. Okay, I just want to quickly run through FOI, EIR, and DPA. Now, why is this including anything about data protection? It's because people quite often say, I want to see all my data under the Freedom of Information Act. Now, it's a valid subject request. The trouble is, it's also technically a valid FOI request. So if you're subject to FOI, you have to answer the FOI request as well, which of course will be a refusal because the personal data of the data subject is specifically of the requester is specifically included in FOI. But you have to say this, and I've had up and down this with the ICO about this, so I speak from experience. Okay, basically what you've got to do is you need to say, okay, I'm not treating this under FOI because it's excluded, blah, 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 therefore I've refused FOI request. However, we're treating this under the data subject access right, therefore we're going to do it this way. Okay, those have to be in writing, by the way. Okay, but that covers all information related to the public sector, but personal data of the data subject is excluded, and sometimes there's a public interest test. Personal data of people in the organisation is also excluded. Okay, so bear that in mind. Okay, yes, I can help you with FOI requests as well. Okay, environmental information regulations only apply to public sector bodies again, and they only cover environmental information. Okay, so they can be verbal or in writing. They're not common in this area, and you're not likely to hit a problem with them interacting with Data Protection Act, as most people know it's not environmental. Okay, but bear in mind the GDPR applies to everybody, okay, not just public sector. Okay, it applies to everybody who processes data. That does include, okay, people like sole traders and stuff like that. The only exemptions are certain household purposes and stuff like that. So if you're keeping your the list of people who are in your that you meet up for squash meetings, or you keep in names of your mates on your mobile phone, that's exempt domestic purposes. Okay, but everything else is covered and you need to register with the ICO. Okay, so just bear in mind they can be included, they can be confused, but also people can mix them in the same request. It's fairly common where you get a complaint that you'll get mixed in with that complaint an FOI and a subject access request. It happens all the time, so be aware of that and look at those things in the line. Okay. Right. I've banged on about data protection officers all the way through this, and I haven't actually explained what they are. So this is basically what a data protection officer is. Okay, it's a lightning rod. Okay, articles 37 through 39 define our legal role. Okay, but basically what we do is we provide expert assistance, we provide advice and guidance, we provide an interface between you and the regulator and you and the member of the data subject. Okay, so yes, you can offload that stopping person to us, that's allowed. Okay, you can also, we provide independent review and audit. So it's our job to make sure that you are following the accountability principles and to help you stay within the accountability principles. So we can do things like, say to you, okay, fine, I want to review all this for you. I tend to do annual audits for most of my customers. Some we don't because there's other audit mechanisms already in place and it'd be duplication. Just bear that in mind. Okay. If you've got a DPO, okay, it's very important that you're clear that and you use them correctly, because they actually can be a great assistance to you. If you don't have a DPO, you're not required to have one unless you're public sector or you're processing on very large scales. Okay, then that's fine. But bear in mind your staff that are dealing with these things need to understand the law, and there's a lot of it. So you may want, if you're on DPO, you may want a available consultancy service. Which brings me to my final slide. So we provide outsourced DPO services, covering everything on the previous slide, obviously. We work for a wide range of organisations. Currently, our major customers are schools and GPs. We have done local authorities in the past. We've also done other companies, and we actually provide services to other companies in the same field, okay, who use us as a subject matter expert. Okay, so just bear that in mind. Our charges are always fixed. We don't do click charges unless you specifically ask for them. So there's no surprises. Okay, you don't have to think about, oh, I can't call in because it's going to cost me money again. Okay, it's a fixed price. Okay, we also do cybersecurity services. I personally am a fully qualified person to do all that sort of stuff. CIPP, ISSMP. What else have I got? TOGAF. Fellow with the British Security Society, chartered IT professional. Anyway, lots. Okay, we got other staff contractors that we bring in to do stuff as well. So we can do all of that for you. We've got a lot of experience in those areas. We also provide the interim IT and IG management. That was my main field before I started the company. Okay, so we're good at that. Okay, and we do ad hoc consultancy at fixed prices for all of those things. Okay, please feel free to contact us on sales@x3.solutions. Okay, and I hope this has been useful. Okay, I'd welcome feedback in the comments, and obviously I'd welcome your contacts and any business you care to throw away. Thank you very much indeed.